Good evening, Kenyon. I'm Tom Carrico on behalf of the Center for the Study of American Democracy. I'd like to welcome everyone for our two-day conference on one of the pressing issues of the day. I want to thank everybody for coming and for really being part of a conversation that we're trying to host over the next couple days. It's good to see a full house. We've got lots of students, faculty, staff, community members, trustees, but also a lot of community members. The importance of this kind of conference topic is it's both timely, but it's also perennial. And that's kind of the idea behind these big events that CSAT puts on from now and again. So the Center tries to provide a forum for both big questions like this, with a slate of activities characterized, as we like to say, by nonpartisan, civil, and sober discourse. And so the Center's activities include a range of things: a speaker series, political debates, summer study opportunities, and other faculty development. And every other year or so, the Center hosts these big conferences. And the idea here, again, is to take a few days out of our busy semester, out of our class schedule, and try to focus our collective mind on some big idea or question and have a kind of all-campus discussion. The Center had a precursor back in the 1980s called the Public Affairs Conference Center. And its reincarnation about 10 years ago was in part due to our beloved political science professor, Pamela Jensen. And the godmother of CSAT is with us tonight. Thank you, Pam. So this year's topic is free speech, civil discourse. It's one of the fundamental questions about civil government, self-governance, and constitutional government. It's the sort of thing that's well suited to a liberal arts kind of inquiry. But these are also issues that have been raised in various college campuses around the country in recent years, sometimes in disturbing ways. Some of the speakers here this week have been shouted down at other places, or even been assaulted for things they have said or written, or guests they have hosted. One recent poll by the Brookings Institution found that, across partisan lines, some 20% of college students thought it was okay to use physical violence to stop speech with which they disagree. Now, whether or not that's true, this is Kenyon, and we don't expect any of that. It's important to note that the Kenyon Faculty Senate last spring adopted a new statement about academic freedom, and we're happy that all the members of that committee are going to be involved in some way in this conference. To gear up on the topic, over the past year, we held some lunch meetings with students, including this past spring when this issue was percolating in the pages of the Collegian. We also poked around and got a lot of ideas about who folks would most like to see. And I'm happy to report that, you know, many of the names that folks most wanted to see are actually with us here this week. There have been some student-organized discussions on campus this fall, and we may have some more later this semester. And as you saw in the pages of the Collegian, CSAT sponsored an essay contest this month, and I'm happy to announce tonight that Kenyon sophomore George Goldman won that contest, which included see here? I don't know who George, all right. So that included a cash prize and the opportunity to have dinner with some panelists tomorrow, so congratulations, George. So in a moment, I'm going to turn the podium over to Kenyon College President Sean Decatur to say a few words and introduce our keynote speaker. Before I do, I've got two pieces of business. First is to preview what's about to come in the rest of the conference, and second is to thank some folks. In terms of the agenda, we're already underway. We began this afternoon with a lively discussion about some fundamentals, about legal, philosophical, and cultural differences that really help enrich this discussion. Tonight, we're going to hear a leading voice on the Constitution, tell us how we might situate the principles of freedom and civility within our constitutional structure. Now, most of the rest of the conference is going to take place over in the Community Foundation Theater in Lower Gun Gallery. And all day tomorrow, we're going to continue with a discussion of a variety of aspects of free speech and civility. You'll hear speakers talk about constitutional law, culture, political correctness, microaggressions, safe spaces, and some very different ideas about how to think about hate speech. You'll hear about some thorny issues on Title IX and You'll hear both some First Amendment absolutism, and you'll hear others, in their own words, making the case for snowflakes. So a wider range, yeah, I'm looking at you, Auric. A wider range of opinion and ideas will be represented. And here's your trigger warning. That virtually guarantees that you're going to hear some folks with whom you likely disagree, which I think is good. Tomorrow afternoon again at 4:30, we've got a public reception in the Gun Gallery atrium, and I really encourage everybody to come out and mingle with our participants. And then finally, to close it all out tomorrow night, back here in Rosse, we've got a kind of free speech-a-palooza panel with Howard Dean, Heather McDonald, and Stephen Pinker. Now, President Decatur has encouraged staff and faculty to take time to come in person to attend all this stuff, and thank you, President Decatur, for that. But we are live streaming all this online just in case you can't get away from your desks. And for those who wanted to join the conversation online, please be sure to use the hashtag KenyonCSAD. Second, and finally, I want to thank some folks. In the first place, the National Endowment for Humanities, whose 2007 We the People grant created the Center's endowment, and for a number of individuals, led by Brackett Denniston, who contributed in matching that effort. We're also especially grateful to the Thomas W. Smith Foundation for significant operating support to keep the center running at the tempo that we have. I'd also like to recognize the George L. Orstrom Jr. Foundation for creating the Distinguished Lectureship on Democracy, which is tonight's event. I also want to acknowledge the Jack Miller Center, which has sponsored numerous events on the Constitution here at Kenyon over the years. And finally, I want to recognize some of the many individuals on campus who were especially instrumental in pulling this off, including the Public Affairs Department, President Decatur, Provost Klesner, CSAD Assistant Director and Professor Nancy Powers, and most of all, my CSAD colleague, Andrea Leckleitner. Andrea, you around here? If you enjoyed any of the conference, please thank Andrea. If you hated it, you can blame Nancy and myself. So that concludes my business. Again, please come back tomorrow morning starting at 9:30 and lasting till 9 o'clock tomorrow night to keep this conversation going. Thank you all.
Good evening, and welcome to tonight's keynote event in the biannual conference of Kenyon Center for the Study of American Democracy. Kenyon has a long tradition of rigorous and balanced examination of important ideas, issues, and policies. The CSAD biannual conference has become a fixture on our calendar that continues and extends this tradition, bringing scholars, thought leaders, and policymakers from across the political spectrum together with our faculty and students for 2 days of intense discussion. This year's topic, free speech, civil discourse, is very timely indeed. Protests in Charlottesville and Berkeley, speakers disrupted, athletes taking a knee on the sidelines, indiscriminate use of Twitter by our commander-in-chief. It seems that everywhere we look, questions about the importance of free speech are coupled with concerns about the coarsening of discourse in our country, making this a particularly important set of conversations for today. In preparation for this week's events, and in particular in preparation for a discussion of the Constitution, I found myself rereading the Federalist Papers recently, and in particular Federalist Paper number 10, which is one of the works by James Madison. While Federalist 10 does not allude specifically to the concept of free speech, it does take up the issue of fracturing the citizenry into factions, a phenomenon that some felt would undermine the stability of a fledgling democracy. In our contemporary setting, with concern about both threats to free expression and growing divides in our culture, Madison's words seem as relevant as ever. Madison asserts that passionately held differences in opinion are just inevitable in any group of people. He says, as long as the connection subsists between reason and self-love, opinions and passions will have reciprocal influences on each other, and the former will be objects to which the latter attach themselves. He continues with the statement that, though written in the 18th century, sounds like it could really be a statement of the 21st. A zeal for different opinions concerning religion, concerning government, and many other points, an attachment to different leaders ambitiously contending for preeminence and power, or to persons of other descriptions whose fortunes have been interesting to human passions, all of these have in turn divided mankind into parties, inflamed them with mutual animosity, and rendered them much more disposed to vex and oppress each other than to cooperate with the common good. Sound familiar? It's as if Madison in 1787 were reading Twitter feeds from 2017. So factions-based differences in opinion are a function of human nature. But Madison also asserts that factions are an inevitable consequence of the expansion of liberty. Liberty is to faction what air is to fire, an ailment without which it instantly expires. And it could not be less folly to abolish liberty, which is essential to political life, because it nourishes faction, than it would be to wish the annihilation of air, which is essential to animal life, because it imparts to fire its destructive agency. In other words, if we want liberty, we will have to find a way to live with diversity of opinion. Madison does not suggest that this will be easy, but in the remainder of Federalist 10, he does propose that the expansion of liberty and the concomitant diversity of opinions is healthy for democracy. To this, I would add, healthy and essential for a liberal arts education. This nearly 230-year-old essay resonates strongly with our contemporary times. There are moments where our society feels more fractious and divided than ever, and this may very well be the case, since the past century has seen expansion of rights to citizens far beyond the select few granted liberty at the beginning of the Republic. No places have experienced this change more dramatically than America's college campuses, where changes in demographics of both the student body and faculty, which began in the second half of the 20th century, have continued and will continue into the 21st century. With this expansion of diversity, it should be no surprise that the college campus has become contested ground on issues of free speech and civil discourse. I'm looking forward to exploring how we as a campus balance the need for freedom of expression, the inherent diversity of ideas and factionalization that comes from expanded liberty, and the equally strong desire to maintain a level of respect and honor and discourse that's critical for an effective learning environment. So this is going to be a great set of conversations over the course of the next day and a half. And I'd like to thank the Center for Study of American Democracy staff, Director Tom Carrico, Assistant Director Nancy Powers, and Andrea Leckleitner for the hard work in putting together this excellent program. And now, I'd like to introduce tonight's speaker, Jeff Rosen, who will give the Wright Orstrom Lecture on Democracy. Jeffrey Rosen is the President and Chief Executive Officer of the National Constitution Center, the only institution in America chartered by Congress to disseminate information about the United States Constitution on a nonpartisan basis. Rosen is also professor at the George Washington University Law School, a non-resident senior fellow at the Brookings Institution, and a contributing editor for The Atlantic. He is a highly regarded journalist whose essays and commentaries have appeared in the New York Times Magazine, The Atlantic Monthly, on National Public Radio, and in The New Yorker, where he's been a staff writer. The Chicago Tribune named him one of the 10 best magazine journalists in America, and a reviewer for the Los Angeles Times called him the nation's most widely read and influential legal commentator. He received the 2012 Golden Pen Award from the Legal Writing Institute for his extraordinary contribution to the cause of better legal writing. It's my pleasure to introduce Jeff Rosen. Welcome.
Thank you so much. Ladies and gentlemen, it is such an honor to be here, and I feel a sense of great responsibility in answering the question that you have set for me, namely, does the First Amendment protect hate speech? I feel this responsibility because you have assembled some of the greatest and most important thinkers in America on this topic, who take different views on the question, and many of them are in this room. It's an important question because it's one of the most urgent constitutional questions facing America today, provoking interventions by the US Attorney General just yesterday to college students across the land. And it's an important question because it's one about which the country and college students are strongly divided. The recent Brookings poll that you just heard alluded to found that 39% of college students believe that the First Amendment does not protect hate speech. 44% believe, 39% believe that it does protect hate speech, 44% believe that it does not protect hate speech, and 14% are undecided. So what I want to do is tell you in as nonpartisan and descriptive a fashion as possible about what the Supreme Court has said about whether the First Amendment protects hate speech, why it has said so, and the principles underlying those decisions. But before I do that, I want to get a sense of what this audience thinks on this important question. And in asking you just to vote before the talk about whether you believe the First Amendment protects hate speech, I want you to do something very important, which is to separate your political from your constitutional views. In other words, you might believe that hate speech is a terrible thing and that it causes grave emotional injury, but the First Amendment does protect it. Or you might believe that hate speech isn't that serious, but the First Amendment allows it. So I'm just asking you as a constitutional, not as a political matter, do you believe that the First Amendment protects hate speech? Who believes that it does? And who believes that the First Amendment does not protect hate speech? All right, a strong majority believes that it does protect hate speech. This is a constitutionally informed audience because I can stand before you as the head of the National Constitution Center with that inspiring mandate from the US Congress to disseminate information about the US Constitution on a nonpartisan basis. That is a serious responsibility. That means that I have to be accurate and as balanced and as fair as possible in telling you what the Supreme Court has said. And I have to tell you about the arguments on both sides of the question, describing the majority opinions as well as the dissents. I can stand before you and tell you with complete confidence that according to the Supreme Court, the First Amendment does protect hate speech. The Supreme Court has said in cases beginning in the 1960s that speech in America can only be banned if it's intended to and likely to cause imminent violence. That's an extraordinarily protective standard. In other words, if one of you were to stand up and say, Jeff is misdescribing the First Amendment, go shoot him now, and that was a credible threat and not a frivolous joke, then you could, and please, Mr. President, should be restrained. At least give me a chance to give the talk. Short of that, though, short of credible, true threats that are both intended to and likely to cause imminent violence, speech in America must be protected. That's what the Supreme Court has said. But that view is hotly contested in America today. That poll I began by quoting suggests that a majority of college students in the poll believes that the First Amendment does not protect hate speech, and others believe that it should not protect hate speech. And you will hear this weekend during this conference powerful arguments by some who believe that the court has been wrong since the 1960s to embrace such a rigorous standard, and that injuries short of imminent violence, such as emotional injury or threats to equality, should be actionable. In telling you the story of why the Supreme Court has embraced this principle that the First Amendment protects hate speech, I'm going to take another step. In addition to saying that the amendment does protect hate speech, I'm going to try to persuade you that it should. I'm going to try to persuade you that the court was right to embrace this inspiring principle. That in channeling our greatest constitutional thinkers, beginning with Madison and Jefferson, moving through Louis Brandeis, the greatest prophet of free speech in the 20th century, and culminating in nearly unanimous Supreme Court decisions of the past 30 years, joined by liberal and conservative justices, the court has embraced a principle that is a shining light of American constitutional jurisprudence and proudly distinguishes us from the rest of an anxious world where emotional injury and dignity can take precedence over free expression. So I've set myself a high task. First, I have to just describe what history has said and the court has said, and then I've got to try to persuade you that it's right. Let me try to do that, and then we'll have a vigorous discussion about this crucial question. So let's begin with the founding. And let's recall that at the time of the framing of the US Constitution, battles over the scope of free speech sparked the Bill of Rights. It was efforts to prosecute critics of King George and of the colonial authorities for sedition that led to the passage of the First and the Fourth Amendment. What was sedition? They were laws based in British common law that prohibited criticizing people in authority. According to the laws of the time, truth was no defense. In fact, the greater the truth, the worse the offense. And so when the printer Alexander Hamilton, combined with John Peter Zenger, published pamphlets criticizing colonial authorities during the colonial era, they were prosecuted for sedition, for criticizing the king, and a heroic jury acquitted Zenger, the printer, on the belief that the sedition laws violated the natural rights of Englishmen and American men and women. And when John Wilkes wrote anonymous pamphlets criticizing the king, and the king authorized his henchmen to break into the houses of British people to search for the author of this anonymous pamphlet, and this led to a conviction of Wilkes for sedition, the jury refused to find damages on the grounds that our right to engage in anonymous criticism was itself a natural right that came from God or nature and not from government. And finally, when the Constitution came to be drafted, after the presidency of John Adams was about to end, Congress passed a sedition law. And the sedition law prohibited criticism of the Republican president, John Adams, but allowed criticism of the vice president, Thomas Jefferson. And Jefferson, understandably, was not amused. And when he became president, he pardoned the critics who were convicted under the Sedition Act. But Jefferson and Madison wrote two totemic pamphlets criticizing the Sedition Acts before Jefferson's presidency. They're called the Virginia and Kentucky Resolutions, and they distill as beautifully and powerfully as any state documents can why Jefferson and Madison believed that the rights of speech and conscience were natural rights that come from God or nature and not government. What's a natural right? Well, the second paragraph of the Declaration of Independence encapsulates the entire theory of natural rights in American government in a single memorable clause. We hold these truths to be self-evident, said Jefferson, that all men are created equal, that they are endowed by their Creator with certain unalienable rights. What's an unalienable right? According to Jefferson, channeling John Locke, Francis Hutcheson, and thinkers of the Scottish Enlightenment, an unalienable right comes from God or nature and not from government. It inheres in all of us when we're born by virtue of the fact that we're human beings. And when we form governments, when we move from the state of nature to civil society, we can alienate or surrender to government temporary control over certain rights in order to secure greater safety of the rights we've retained. We can allow the government to punish violence, for example, in order to increase the security of all. But certain rights can't be alienated to government because they inhere in what it means to be an autonomous human being. And the quintessential unalienable right are complete rights of freedom of conscience and opinion. Jefferson was a man of the Enlightenment. He believed we all have certain faculties, beginning with passion at the bottom to reason at the top. And we have a duty to cultivate our faculties of reason so that we can be fully free. Jefferson believed that I can't alienate to government my ability to reach opinions based on reason because my reason defines who I am as a human being. And when the government tries to coerce me into believing or not believing in one God or another, or into criticizing or not criticizing one official or another, it violates my unalienable rights of conscience. So that was Jefferson's case against the Sedition Acts, and it was vindicated when he pardoned its critics. Nevertheless, the Supreme Court for most of the 19th century disagreed and continued to allow the conviction of people who gave speeches that might have a bad tendency to encourage law-breaking in the future. So the next great drama over free speech and sedition occurred during World War I. And anxious about anarchists and terrorists who were blowing themselves up in the streets, Congress passed the notorious Espionage Act of 1917, which essentially made it a crime to criticize the war effort. Eugene V. Debs, the socialist candidate for president, ran for president from a jail cell in 1920 because he stood on a soapbox and made a mild speech criticizing World War I, saying, "Resist the draft, this war is the tool of capitalists like J.P. Morgan." Louis Brandeis, my hero, the great prophet of free speech, who I want to urge on you as a model for reason, initially voted with a majority of the Supreme Court to uphold the conviction of Debs and other critics of the war, because the law was so established that any speech that might have a bad tendency to encourage lawbreaking could be banned. But over the summer of 1919, Brandeis and Holmes changed their mind about free speech. They did so for different reasons, but that change of mind has transformed the modern understanding of free speech. Holmes came to believe in the necessity of a libertarian marketplace of ideas. He had read John Stuart Mill, who insisted that only when citizens have access to all arguments can good ideas triumph over bad ones. The best test of an idea is its ability to triumph in the marketplace of ideas, said Holmes. And this military metaphor came from his experience in the Civil War. He almost died at Antietam. And there he lost faith in abolitionism and all ideals, and came to believe that unless the majority could impose its will on the minority through law, then open violence would result. But in order for the majority to rule by law, he thought all ideas had to be admitted to the marketplace of ideas so that good ideas could crush bad ones. It was a powerful libertarian vision, but it was not an idealistic one. Brandeis had a more idealistic and Jeffersonian view. And he read Jefferson in 1919, and he continued to read Jefferson over the summer of 1926, when he read Jefferson's first inaugural, where all Federalists, where all Republicans, said Jefferson, insisting on the need for both sides to converge in a civil conversation. And he also read Jefferson's letter to Elijah Boardman, the Connecticut preacher, where Jefferson insisted on the importance of untrammeled freedom of conscience as a natural right from God or nature and not government. And then Brandeis read another important source, and that was the ancient Greeks. And we heard during the panel this afternoon about the Greeks' complex views about free speech and how fascinating it was to learn about the distinction between their more communal notion that all ideas had to be admitted into the agora so that people could educate themselves, and the more libertarian notion that self-expression required that all could speak. And Brandeis read a book called The Greek Polis by Alfred Zimmern, which was his favorite book, and which he distributed to all whom he met, because he believed that 5th century Athens was the apotheosis of the Jeffersonian democracy that he idealized in rural Kentucky. He thought of the polis and the Jeffersonian shire as a place where citizens face to face could look at each other and deliberate and cultivate their faculties of reason. And Brandeis believed that as long as there was time enough to deliberate in these small-scale communities, then the best response to evil counsels was good ones, because he had such faith in the ability of citizens to reason together. And it was that Athenian and Jeffersonian faith in reason that led him to embrace the principle that speech could only be banned if it was intended to and likely to cause imminent violence. Because Brandeis thought, as long as there's time enough to deliberate, then reason will prevail, and to exclude hateful speech, which Holmes so memorably called the thought we hate, from the discussion would be to prevent citizens from developing their faculties of reason. And Brandeis encapsulated this astonishing Athenian and Jeffersonian faith in his concurring opinion in Whitney versus California. And I'm a law professor, so I get to give you homework. And the homework after the show is read Brandeis's beautiful concurrence in Whitney. It's the most inspiring statement of free speech in the 20th century. And as a party trick, I can now recite to you one passage from Brandeis's opinion. But I want you to treat this seriously, because the words are very important. And Brandeis's message is extremely important, and I'm going to tell it to you as seriously as I can, and think about each word and try to understand as deeply as you can what Brandeis is saying, so you can try to understand the power of his Athenian and Jeffersonian defense of speech. And what I want to stress is that Brandeis begins by talking not about Hamilton and Madison and the framers of the Constitution of 1787, but of Jefferson and the revolutionaries of 1776. Here are Brandeis's inspiring, meaningful words. Those who won our revolution believed that the final end of the state was to make men free to develop their faculties, and that in its government, the deliberative forces should prevail over the arbitrary. They valued liberty both as an end and as a means. They believed liberty to be the secret of happiness and courage to be the secret of liberty. That's a quotation from Pericles' funeral oration, as translated by Alfred Zimmer. They believe that freedom to think as you will and to speak as you think are means indispensable to the discovery and spread of political truth. That without free speech and assembly, discussion would be futile. That with them, discussion affords ordinarily adequate protection against the dissemination of noxious doctrine. That the greatest threat to freedom is an inert people. That public discussion is a political duty, and that this should be a fundamental principle of the American government. The faith in reason is overpowering. Come, let us reason together, said Brandeis. How remarkable and how arduous a conception of citizenship he has. Public discussion is a political duty. We have a duty to educate ourselves, to develop our faculties of reason, to be worthy of public deliberation. We're not capable of participating intelligently in a deliberative discussion unless we've taken the time, the arduous time, to educate ourselves about important matters of public significance, to gather the facts that are necessary to make an informed decision, and to reason with our fellow citizens. And that's why Brandeis has such faith that as long as there's time enough for discussion, no hateful counsel may be excluded from the public discourse, because reason will ultimately prevail. It's a stunningly inspiring Enlightenment, Jeffersonian, and Greek vision of the power of reason and the centrality of speech. So we need to ask ourselves now a crucial question. Was Brandeis correct? Was he too idealistic in insisting on the ability of reason to counter evil counsels? And was the Supreme Court correct when, in 1969, it embraced Brandeis's vision in a case involving hate speech? This was a case where a member of the Ku Klux Klan stood up at a Klan rally and said, unless white people are attended to in this country, there could be some revengeance against African Americans. Hateful speech at a Ku Klux Klan rally. And that was challenged as a form of hate speech. And the US Supreme Court rejected the challenge, and citing Brandeis's concurrence in Whitney, said that although the speech was offensive, it was not intended to and likely to cause imminent violence, and therefore even hateful speech at a Klan rally had to be protected. And that principle in the Brandenburg case from 1969 has been affirmed again and again, so that today, if the case were to come before the current US Supreme Court, I think that perhaps at least 8 justices, if not all 9 of them, would hold that hate speech is protected. In a case involving the Phelps Baptist Church, where protesters made hateful and appalling statements against gay people because of their views about the military's policies involving gays in the military, the Supreme Court, by an 8-to-1 vote, held that that hateful speech was protected. Only Justice Samuel Alito, interestingly, took a more European view that dignity could trump liberty. Alito said that the dignity of the family members who might suffer serious emotional injury at this hateful and appalling speech could be actionable by law. So what we need to think through together is, under what circumstances should dignity trump liberty? This is a question that Europe has answered in a different way than America. In Europe, hate speech is illegal, and if you can't deny the Holocaust in France or Germany, and if online you engage in speech that is hateful, you can suffer serious sanctions. So should we embrace a more European view of free speech, and was Brandeis correct? What's so powerful about Brandeis's example is that he grappled with precisely this question and came to change his own mind about the balance between dignity and liberty. As a young scholar, in 1890, he wrote the most influential article on the right to privacy in American history, in which he argued that dignity should trump free speech. The article is called "The Right to Privacy." It was published in the Harvard Law Review, and it was published in the wake of new technologies, namely the Kodak camera and the instant press, that were guaranteeing that gossip that used to be whispered in the closets was now shouted from the rooftops. I learned recently from a scholar of photography that 1890 was the first year that tabloid newspapers began mass distributing photographs. And it was these photographs and the gossip about Brandeis's law partner and his wife's friendship with President Grover Cleveland's young wife that led Brandeis and Warren to try to propose a cause of action for the emotional injury that could result when celebrities were gossiped about in the newspaper. But Brandeis and Warren looked through American law, and they found no remedy, because our law, unlike Roman law, said Brandeis, contains no remedy for offenses against honor. And so Brandeis and Warren proposed a series of remedies. They're known today as the Brandeis torts. They sound like a delicious dessert. But they're an unsatisfying area of law because they allow people to sue when their dignity is affronted by public gossip. Essentially, the modern version of the Brandeis torts is the Hulk Hogan case, where celebrities say that really offensive videos about them should be taken down even though they're not false or libelous, because they can cause emotional injury. And the reason that the Brandeis torts are unsatisfying is because they hinge on whether an ordinary observer would find the speech in question highly offensive. And Brandeis himself came to conclude that that was a decision in democracy that citizens, not judges, should make for themselves. Soon after Brandeis wrote the article, he wrote to his wife, Alice, his beloved wife, and said, "I reread the privacy article. It's not as good as I thought it was." He came to believe that sunlight is the best disinfectant, electric light the best policeman. He became more interested in transparency, in promoting accountability, than allowing judges and public officials to balance the public's interest in learning about celebrities against their dignitary interests. And he came to believe, like Jefferson and the Greeks, that in a democracy, citizens had to decide for themselves exactly what kind of speech was of public interest. That doesn't mean that Brandeis lost interest in privacy. On the contrary, he reconceived privacy as a right that could reinforce free speech and dissent rather than thwart it. And in his beautiful dissenting opinion in the Olmsted case, Brandeis reconceived privacy against state surveillance as a kind of intellectual privacy that was necessary for free expression. A majority of the court upheld the conviction of a bootlegger whose phone had been wiretapped without a warrant, on the grounds that because there was no physical trespass in placing the wire, the Fourth Amendment to the Constitution wasn't violated. And in this amazing prophetic dissent, Brandeis looks forward to the new technologies that are confronting us today. He has in his desk drawer a clipping about a new technology, television. It's 1927, but he misunderstands television. He thinks it's a two-way technology where people can see each other through both ends of the screen. He anticipates Skype and webcams. And his law clerk said, "You can't just look out of a camera and see someone on the other side of the screen." Now, of course, you can. But Brandeis alludes indirectly to television in this amazing concurrence, and also to cloud computing, where our data is stored outside the home, and to fMRI mind-reading technologies that can reveal unexpressed thoughts, sensations, and emotions. And in this amazing and prophetic concurrence, these are Brandeis's words. He says, "The progress of Science and invention is not likely to stop with wiretapping. Ways may someday be developed by which it's possible, without physically intruding into the home, to extract secret papers from desk drawers and introduce them in court. Advances in the psychic and related sciences may make it possible to reveal unexpressed thoughts, sensations, and emotions. At the time of the framing of the US Constitution, said Brandeis, the general warrants that sparked the American Revolution by trying to enforce sedition laws were held to be a violation of the Fourth Amendment. We must translate the Constitution, said Brandeis, so it protects the same amount of privacy and free speech in the electronic age as it protected at the time of the framing. So you see the beautiful coalescence of Brandeis's views about privacy and speech. By preventing the government from peering into our minds and reading our web browsing and surveilling our movements in public, thought Brandeis, our ability to dissent and to express ourselves as autonomous individuals would be protected. And yet by preventing fellow citizens from saying what they pleased about each other and from trying to exclude hateful or offensive speech from the public sphere, Brandeis believed citizens could fully develop their faculties of reason and actualize themselves as citizens engaging in their duty of public deliberation. So that's Brandeis's view. What should be ours? Now, as you students of Kenyon, because I'm talking to you, I'm trying to persuade you that Brandeis's view is not only adopted by the Supreme Court and at the moment the law of the land, but is also correct, because it will be in your hands the future of the First Amendment. The First Amendment has not, as I've described it, protected this beautiful Brandeisian Jeffersonian view for most of its history. For most of the 19th century, up to as late as the 1960s, the Supreme Court allowed the suppression of hate speech. And therefore, if you are not persuaded that this is the correct interpretation of the First Amendment, then as the law broadly tends to follow trends in popular understanding of the Constitution, in 20 or 30 years when you are running the country, then the First Amendment will not protect hate speech. And this question is all the more urgent because our current free speech battles are not just taking place on campus, they're taking place online. And at the moment, Facebook and Google, as Eugene Volokh said this afternoon, have more power over who can speak than any university president or even any king or US president or Supreme Court justice. And yet Facebook and Google and Twitter, where all of us do our speaking, are not bound by the First Amendment. The First Amendment says Congress shall make no law. It doesn't say Mark Zuckerberg shall make no law. And as a result, Mark Zuckerberg and his colleagues at Google and Twitter have embraced hate speech policies that, although not as restrictive as those in Europe, allow the banning of more speech than the First Amendment would permit. On Facebook and Google, it's illegal to say, I hate a religious group, but you may criticize a religious leader. And therefore, when a video called The Innocence of the Muslims circulated a few years ago and was blamed for causing the Benghazi riots, both President Obama and the President of Egypt demanded that Google and Facebook remove the video. They consulted their hate speech policies, concluded that the video said, I hate the Prophet Muhammad, but it didn't say I hate Muslims, and therefore left the video up. As it turned out, that was a good decision because the Benghazi riots appear to have been caused by other factors, and the video had been up in Arabic for months before the riots. So these young people at Facebook and Google made a better decision than President Obama and the President of Egypt. But what is it like to live in a world where young lawyers at Google and Facebook, often wearing t-shirts and wearing flip-flops, have more power over free speech than the President of the United States or the US Supreme Court? And what does it mean that the law that they're enforcing is not the law of Jefferson and Brandeis, but the law of Facebook and Google? Facebook's content policies were shaped by a bright young graduate of Bowdoin College who had been running the help desk of Facebook when the company started, and then as it got big really fast, was suddenly promoted to writing the law of free speech for the entire world. And he had to do it fast, and he'd read John Stuart Mill in an anthropology class in college. So what you guys are studying right now is really important. And he somehow, from Mill, extracted the distinction between criticizing a religious leader and criticizing religion. Not totally obvious from Mill, but an interesting interpretation on liberty. And as a result, it was written into the Facebook policies, and Google, which owns YouTube, adopted the same distinction and wrote it into their policies. And that's now the law of the world when it comes to free speech. We need to think hard about whether that line is the right one, and also what to do in a world where these platforms are unconstrained by constitutional values. It's all the more urgent because all of the pressure in the world is coming in favor of the suppression of hate speech. And I'm going to tell you about one more case in Europe, and then we'll have a discussion about these questions. If we were in Europe right now and someone were to tweet, "Jeff has really gone on too long, I don't want to shoot him, but this speech is really boring and I expected it wouldn't have so much Brandeis in it." After the show, I could basically sue you under a European right called the right to be forgotten. This amazing right has its roots in France, unsurprisingly. It's from the French droit à l'oubli, or the right of oblivion, which is so French. It's right out of Sartre. You know, I want to be forgotten, and Americans want to be remembered. But this is not amusing, because the European Court of Justice, in a recent decision, held that any data subject, that is anyone in Europe, who feels that their dignity has been affronted and that data about them is not relevant, can demand that it be taken down, and Google and other search engines have to make a decision about whether the individual in question is a public figure and whether the speech contributes to public discourse and has scientific or literary or other public value. And if Google or Yahoo guess wrong, and a European Privacy Commissioner second guesses them, then Google is liable for up to 2% of its annual income, which last year was $60 billion. So if my math is right, $12 million fine per incident, or maybe it's 120 million, you math it, how much is it? 1.2 billion. I mean, you see why I teach Constitution and not math. $1.2 million fine per incident concentrates the mind. So as a result, Google has removed 53% of the takedown requests it's received in Europe, including requests to remove articles about the right to be forgotten itself. So here you see now you see the stakes of this debate about the battle between dignity and free speech. The claim that speech can be banned because it affronts dignity cannot be cabined to a particular group or a particular campus or a particular historical incident. It can't be said that this group's dignity is more vulnerable than that one's. Once you empower regulators, and right now these regulators are just as likely to be faceless Facebook employees as they are judges, to make decisions about under what circumstances my dignity should trump your outrageous and unfair tweet, you surrender the ability of citizens to govern themselves. And then all of a sudden you understand that Brandeis's insistence that public discussion is a political duty and the decision about what kind of offensive speech is relevant or not is one that citizens have to make by reasoning together is so imperiled. Now there is one final important, there are many final important technological questions that we need to discuss together now, but I think the one I want to tee up is the obvious one. Was Brandeis's faith in time too optimistic in light of new technologies? The entire Brandeisian vision is based on the idea that there's time enough to deliberate. As long as there's time enough, then reason can prevail. But today there's no time. Public discourse is so fast, and we're making fundamental constitutional decisions based on one-off Brexit votes and making policy by tweets. This is the antithesis of the Brandeisian and Madisonian vision. The entire constitutional system is premised on the idea that there is time enough for thoughtful deliberation. Madison and Jefferson, who defended the natural rights of conscience, also studied failed democracies like Greece and Rome. That is why these Greek and Roman and Athenian examples are so important. They believed that unchecked, direct democracy led to demagogues and the mob. And that's why they created a constitutional system designed to slow deliberation down. The worst offense, according to Madison in Federalist 10, was for representatives to communicate directly with their constituents. Madison would not have approved of tweeting presidents. I can say that with total nonpartisan certainty as head of the National Constitution Center. Direct communication between representatives and their constituents was the anathema to be avoided because of this powerful sense that only with time to deliberate and through filters could thoughtful policy emerge. And just to reaffirm the point, the whole distinction between a constitution and an ordinary law is the idea that the Constitution emerged thoughtfully over time. It was the special ratifying procedure of the Constitution, the fact that it was proposed by a special convention and then ratified by 3/4 of the states, that gives it the authority to speak in the name of we the people. And not to, I was going to wrap up, but I have to now make the connection between the importance of defending free speech and the very justification for courts' ability to strike down unconstitutional laws. Hamilton says in Federalist 78, the reason that unelected judges can strike down laws as violating the First Amendment is because when there's a conflict between the will of the people, represented by the Constitution, and the will of ordinary legislators and representatives, represented by statutes, we prefer the will of the master to the servant, the principal to the agent. That's the whole theory of judicial review. And the whole system is based on this idea that the First Amendment and the rest of the Constitution represents the considered will and belief of the people more profoundly and sustainedly and in a more meaningful fashion than the latest Twitter poll or law passed by Congress. So that's why it's so tremendously important that we have this discussion about whether you, the people, still believe that the First Amendment is a natural right that comes from God or nature and not from government. That it does prohibit the government from telling people who can speak and who can be heard, and that to restrict the speech we hate because it causes emotional injury would violate those natural rights. I say with great earnestness and seriousness that the future of the Constitution, students of Kenyon, is in your hands. So it is very important that we have this discussion, and I'm eager to have it with you now. Thank you very much indeed.
So I'd encourage folks to just line up here in the two aisles. We've got microphones on both sides. Both students and participants, just go ahead and bracket. You got to get in line. Got to get the microphone. Go ahead.
Thank you. My name is Eva Warren. I'm a junior and a sociology major. I wonder how your criticism of Facebook's moderators and similar social networks changes, given the fact that it's a voluntary community that you join and you do agree to terms and conditions.
Yes, I could choose not to be on Facebook and should restrain myself. I could choose not to use the bank. I could choose not to walk around in public and have Amazon drones track me in the air, or I could choose, to put the point more directly, not to use a cell phone and not to emit my movements so that they're stored and collected by the government and could be reconstructed. But in practice, I can't, because Facebook is our public square. And more than 1 billion pieces of content are exchanged on it. And were Facebook and Google to adopt the Soviet rather than the American view of the First Amendment, then speech in America in practice would be dramatically different. This is not a constitutional argument at the moment. It's an argument in practice about who can speak and who can be heard. And remember that for Mill and other great thinkers of free speech, the greatest threat to speech was not government, it was public opinion. It was the censure of the tyranny of the majority that might censoriously oppose unpopular views. So Mill's main concern is not state action, but when public disapproval is going to inhibit people from freely speaking their minds and expressing their autonomy. So if I don't have access to the platforms where people speak and can be heard, or if fear of censure on Facebook inhibits me from speaking the truth, then free speech will suffer. That's the moral or ethical argument for why I think it's important for Facebook and Google, as companies who claim as their mission to favor the free exchange of ideas, to embrace voluntarily something like the American view of the First Amendment. It could be worse. They could adopt a more European view. It could be better. They're sort of Goldilocks-like in between. But then that does raise a second level of constitutional question. Should we amend the Constitution to regulate Facebook? Or should we use our antitrust laws to break up Google? These are both Brandeisian and Jeffersonian questions. Jefferson proposed an amendment to the Constitution that didn't pass that would have prohibited Congress from setting up monopolies or other corporations with exclusive privileges. And this anti-monopoly tradition was channeled from Jefferson to Andrew Jackson in his criticisms of the hated monopoly of the Bank of the United States, through Brandeis, who immortally criticized the curse of bigness in business and government and the risks that banks like JP Morgan took with other people's money, recklessly investing in complicated financial instruments whose value they couldn't understand and leading to financial crashes. He predicted the crash of '29 and would have predicted that of 2007. So should we have a Jeffersonian amendment that prohibits media platforms from infringing free speech? It says Facebook, tech platforms shall make no law abridging the freedom of speech? Or should antitrust laws be used to prevent Facebook and Google from exercising their monopoly control over our speech platforms to censor speech? That's also a Brandeisian proposal. In the election of 1912, all three candidates favor breaking up the big banks because they oppose monopoly power, but they do so for different reasons. Brandeis, the Jeffersonian, wants to break up the banks so they're too small to threaten liberty. Theodore Roosevelt, the Hamiltonian, wants to create big regulatory bodies to oversee the big banks. And William Howard Taft, the incumbent president, wants to use antitrust laws to prosecute the big banks. Taft, for what it's worth, is the subject of my next book, and he's also a hero of sorts. He was our most judicial president and presidential chief justice who views every decision in constitutional terms. And it's significant that in 1912 there was a consensus among all three candidates, for very different reasons, that monopoly power was dangerous. The fact that there's not one today, although just now there's new interest in regulation of the platforms with an understanding of their role in the election and their power over speech, is striking indeed.
Jeff, just let me continue that part of the conversation. Oh, I'm sorry. Go ahead.
You're fine. Just wanted to say thank you for coming. This has been swell, to say the least.
Thank you. That's a great compliment. I'll take that one.
Yeah, forgive my dead monotone speech. I'm a sophomore. I wrote this down because I'm a pitiful public speaker. Okay, so we protect hate speech. That's cool. I'm down for it. I dig it. I was just wondering, is it not unfair, almost to the point of being unconstitutional, that the more privileged someone is, the more immune they are to the impacts of hate speech? There's very little I can say to, for example, a straight white male lacrosse player to hurt him or otherwise impact him, but should he target me, he is one by default. If what he say has to impact, let's say, my upward mobility, where is the equal opportunity in that? I would like to reserve the equal opportunity to hate as well as to succeed socially.
Really powerfully said, eloquently said, more than swell, beautifully put. And that's the genesis of a new constitutional argument. And it's a really serious argument you just made. And there are legal scholars who are trying to frame that in constitutional terms, just as you said. And there's a scholar called Shannon Gilchrist at Wake Forest University who has an article out arguing that to the degree that hate speech can violate the equality of marginalized groups, as well as their dignity, then it should be actionable under the Equal Protection Clause as a violation of equality. I haven't heard him debate, but tomorrow the Constitution Center sponsors a great weekly podcast where I get to interview the best liberal and conservative scholars in the country. And tomorrow we're doing hate speech. I was inspired by this conference. So Shannon Gilchrist is going to debate Keith Whittington from Princeton, who's just written a great book on why free speech is important in a university. And I don't know what they're going to say, so check. It publishes on Thursday, and it'll be really interesting. So I'll have a better answer for you after I've really heard his argument fully and so forth. But I guess my constitutional answer is the Supreme Court at the moment has not viewed dignitary injuries or structural inequality as the kind of injury that's actionable under the Equal Protection Clause. But that doesn't really answer your question, because you're saying it should change its mind. And I guess I would have to say that the incredible unfairness and inequalities that you're talking about have to be dealt with at the root level. I mean, these are terrible unfairnesses. The structural racism that keeps down minorities and denies people opportunities, the privileges that white men have enjoyed are economic. Those Brandeisian concerns about monopoly power and wealth inequality that are empowering the 1% in the big banks and disempowering working class people of all races are serious questions. The mass incarceration problem is central, and it's a shame that the bipartisan consensus about the social effects of mass incarceration, which prevailed until recently, have been stymied. These are, I could go on. You're talking about the most serious social problems in America. They're not.
Words, affirmative action, I'll give you $75 million.
Well, affirmative action. Absolutely. Yay! See you guys. I'm going to Rio. But banning hate speech isn't the answer. That's not going to solve. Those problems are serious. Those are serious problems. The fact that people feel offended, of course, it's terrible to feel that offense, that pain. But it's not going to work. It's not going to solve anything, and it can lead to terrible effects. Just think, I'm talking about you. You could be on the Supreme Court in 30 years. You might be on the Supreme Court. You're on the, yes. You might well be. It's not, actually, it's a pretty cushy job. You only work like eight months a year, and it's fine. You like it. And and you'd be a great justice. And you start allowing hate speech to be banned because it might cause offense and is not going to solve these other structural problems. And then some future illiberal president is going to be saying that people should be locked up because they don't say the Pledge of Allegiance. Hypothetically. On a nonpartisan basis, I'm giving you that hypothetical. And you start allowing the banning of offensive speech, and the government's going to start imprisoning its critics, because it's done that every single time before. We've seen this happen a lot of times. So that's my answer. Okay.
Jeff, I want to pick up a thread on both the very good question you just had and then on the issue you were talking about, could you regulate Facebook and other institutions like that? So first on the hate speech issue. The hardest part of the Brandeis argument when it comes to hate speech is the predicate for the Brandeis argument and the Holmes argument is that we live in a marketplace of ideas, and the truth will emerge from that marketplace of ideas. And that truth emerges from reasoned expressions. The argument might be, as to hate speech, there's no reasoning in hate speech. Hate speech is an assertion, an insult. So the argument goes. I don't necessarily agree with this, you know, from our brief conversations today that I don't. But that to me is the hardest argument. How does hate speech contribute, or can it possibly contribute to that marketplace of ideas. So I have that question, then I have another question, but.
Jews are inferior. Black people are inferior. That hugely contributes to the marketplace of ideas because it can be reasoned with and argued with. Even the insult, Jeff is worthless, or Jews are worthless, is a contribution. Because Jefferson and Brandeis thought you can't distinguish between fact and opinion. They were very keen on the importance of all opinions to be admitted into the marketplace, even false ones, because the decision about whether something was false and whether it was worthless had to be something that democratic citizens made on their own. Now, I think the more serious, so I'm not saying that's a serious challenge, but I'm persuaded by the argument that it's not up to you or me or any individual.
Because somebody's going to have to make a decision about what's hate speech and what's not.
Well, basically about what, whether or not to follow it, whether to be persuaded by it. One person's opinion is another person's fake news. And Senator, I was going to say Senator Moore from Alabama, but I guess he's got to win the election first, may express views that some consider hateful, but in the course of rejecting it, citizens decide what kind of society they want to have. I think a more rattling challenge to the Brandeisian faith is the impossibility of agreeing about facts, not about opinion. But the idea of fake news would have been really unsettling to Louis Brandeis. This is the apostle of facts who says that we have a duty to spend our time reading industrial reports rather than watching cat videos, because we need to assemble the facts that are necessary to make an informed discussion. The idea that we could live in a society where citizens can't agree on what is true is entirely anathema to the Brandeisian and Madisonian faith and the possibility of reasoned discourse. So coming up with ways to help citizens converge around truths seems to me an urgent necessity, but not a reason for banning.
The problem with that, trying to have a principle that addresses that, is what's the measurement of time? So the classic Brandeis formulation, or it's Holmes' formulation really, is yelling fire in a theater. We all know that's immediate, and that there's no time to have a reasoned conversation about that. But developing a principle that says, okay, when is fake news going to be disseminated quickly enough that we can't protect it, is impossible. It's impossible. And it also assumes that it isn't corrected. And it frequently is corrected unless, and this is the Brandeisian principle, there's an imminent threat of danger. Not just misinformation, but danger. And that's the problem with regulating fake news, because there's not enough time.
You've just made the case better than I could. You're absolutely right. And the idea of trying to stop it in time is unrealistic in an age of instant dissemination. But the fact that there's no time is a big problem for Brandeis and for Madison, because if there's not enough time to deliberate, and if people are going to make instant decisions based on Twitter mobs and fake news and go into polarized camps, then this possibility of thoughtful deliberation is elusive. This is not an argument for regulating speech, but it's a deep problem for American democracy. The whole system is set up to slow things down, and now things are moving really fast. We're in really big trouble. We had a great conversation earlier, and I mentioned this great project the Constitution Center has to ask, what would Madison think of our current presidency, Congress, courts, and media, and how can we resurrect Madisonian values of thoughtful deliberation today? The opening panel was with Ryan Lizza from The New Yorker. We're thinking about the future of media. And I asked him, why is Congress broken? And he said it's the transparency. The Constitutional Convention was secret. The fact that people were locked in a room between May 25th and September 17th, 1787, there were no leaks. allowed the biggest compromises in American history, the balances between the large and small states and the slave states and the free states, for better or for worse, were able to compromise because there were no leaks. Ryan said, now that positions are tweeted in Congress in real time, R's and D's can't come to compromise even if they want to, because their bases will kill them. So this is one of the great political journalists of his time saying total transparency is not conducive to deliberation in Congress or to public deliberation. So we're identifying together some of the problems, and the next step will be to come up with some solutions to slow things down and to have more time.
So my second question really goes to this Facebook example.
Wait a minute. That's about your fourth question.
I'm the moderator.
Who sets the rules here?
I think, there we go. After you, my dear Alfonso. Are you going to cede to Professor Fish?
No, I cede the floor.
Okay, that's so generous. That's a model of reasoned discourse.
A wise decision. 2 points. The first point is that I agree that hate speech not only should not, but could not be banned, because there is no such thing as hate speech. Hate speech is an unstable category. The only way it could be stable is if you could identify a set of propositions that was just hateful, and that will never work. So my definition of hate speech is simple. Hate speech is speech loudly and forcefully produced by persons whose views you despise and fear. That's hate speech. But my main point is to provide an antidote to what I take to be the sermon that you just delivered. The sermon that you just delivered, that is, you gave us a perfect and I think well-informed and extremely eloquent version of what I would call free speech theology or free speech worship. And I think the facts that you rehearsed are correct and the order is correct, but I would re-rehearse them with a somewhat different spin on them. I do believe, as you do, that in the late 19th and 20th century, when the standard was bad tendency, there speech was evaluated on the basis of the effects people thought it might have. And that then gave way to the Brandeis Holmes clear and present danger, which became progressively refined to the point where the danger would not even be reached if outright military action was being at least argued. At the same time, another way of evaluating speech, evaluating speech by its content, which is also part of the 19th and early 20th century understanding of free speech, was abandoned. Now, as late as 1943, I think it's 43 or 42, you I'm sure would know, in a case called Chaplinsky versus New Hampshire, there's a famous paragraph in which there's a list of forms of speech that do not rise to the level of constitutional protection. Why? Because the court said, because they make no contribution whatsoever to the serious exchange of ideas. Now, that lasted for a brief time, and the death knell to the content test was delivered by a case from which you were querying a few moments ago in your response to a question, and that is, of course, New York Times versus Sullivan, which is every First Amendment's ideologue's favorite case, and which is my least favorite case. Now, what New York Times versus Sullivan says is that even falsehoods must be protected. Even falsehoods must be protected. Why? Because they contribute to a robust, uninhibited, and wide-open conversation, which I have sometimes called the John Wayne theory of the First Amendment, the kind of wide open spaces. So you've got no content way of evaluating speech, no effects way of evaluating speech. What do you have left? You have instead the embrace of speech as speech, no matter what its contents or what its effects. That it shouldn't be questioned, it shouldn't be accepted. It is, in short, in the position of a deity. And that is what has happened. That is, you have the ideology of free speech. And in the present court system, you're quite correct again, only Alito, in a series of dissents, is speaking out against this. The ideology of free speech is founded exactly as you said, mainly on Brandeisian ideas. And you have named some of them, and I'll name 2 or 3 more of them. The first is that sunshine is the best disinfectant. That is, if you let bad ideas into the light of day, everyone will recognize that they are bad, and in a kind of reverse Gresham's law, they will disappear. The second is the remedy for bad or harmful speech is more speech. And the third, the capstone to this, was proclaimed in a case called Gertz v. Robert Welch. Under the First Amendment, there is no such thing as a false idea. All of these make up the promise of the marketplace of ideas. And the promise of the marketplace of ideas is, again, that in time, if you let everything be said and repress nothing, the good will be winnowed from the bad, and the good will be then our position. And as I have often said, probably in your presence, the only argument against this idea that in time the good will rise to the top and the bad will be banished, the only argument against that idea is all of recorded history.
Professor Fish, you're correct. I did give a sermon, and I tried to channel the idea not that speech is a deity, but that men and women are made in the image of the deity, of nature's God, as Jefferson believed, and that it is our natural right to express ourselves freely, regardless of whether our views lead to the spread of truth. That is the autonomy-based, Jeffersonian, natural rights-based vision of free speech that the founders believed was inherent in us, and that I think the court was right to embrace. But even your more collectivist notion that speech, well, we learned the Greek roots of it this afternoon in riveting detail, that when speech is admitted collectively, it will educate people. Whether or not truth has emerged, we've learned that the alternative, which is to allow government censors to make the decision about what sort of speech should be admitted into the public sphere, will lead to tyranny and destruction and oppression. So even on pragmatic grounds, even if you reject the autonomy-based claim that we all have a natural right to express ourselves as we please, you must reject the importunations of the claim that any regulator or body or government can better decide who can speak or who can be heard than the people themselves.
Well, you should just work to do that.
Well, of course, and that's why I'm giving you this sermon, because this is very important that you're persuaded by my speech, because if you're not, then democracy will perish. And that's why we're going to vote again at the end of the speech and see if I've persuaded any people who were not convinced at the beginning.
Hi, so I have a question pertaining less to the nature of free speech and more to the venue. So if one imagines, the Greek agora or, the pastoral marketplace of ideas that Jefferson envisions, you're going to have a group of people who come to a location and they're on literally equal footing with each other. No one is elevated, no one is given any, fancy titles or decoration or elevation of their ideas. And I think that a lot of student protests targeted at ideas which are brought to campus are less a complete rejection of their right to speech and more of a rejection of the elevation that a school-sanctioned guest speaker gets. Because oftentimes there's very expensive fees for the speaker, number one. There's oftentimes lots of security measures. It's also taking up valuable time and resources of the university, which many students think should be dedicated to speakers who perhaps have a certain level of civility or respect for the identities of the student body that perhaps aren't met by a prospective speaker. So I'm wondering if you feel that it is just or whether right or constitutional for specifically private institutions to repel speakers which don't meet these certain levels of decency in which students are able to actually feel like they can participate in the exchange of ideas on an equal plane.
By repel, do you mean students should shout them down?
Either that students shut them down when they arrive to campus, or that administrations disinvite. Oftentimes there's a student organization that wants to bring Milo Yiannopoulos to campus, and oftentimes administrations are compelled by the student body, by professors, that they should disinvite. So whether they should make that call to disinvite or not.
Shouting down and disinviting is not consistent with the Brandeisian view of the First Amendment. The heckler's veto holds that the fact that you really disagree strongly with a speaker or think that their views shouldn't be elevated is not a decision that you or a minority or even a majority of students should be able to make on their own, because any group of students has a right to admit unpopular ideas to be heard. And disinvitations are in the same spirit. Erwin Chemerinsky, the dean of Berkeley Law, was quoted in the New York Times today as saying the initial invitation is a trickier matter. He's a complete Brandeisian civil libertarian, but he said now that it costs $1 million to protect a speaker because of the fear of the heckler's veto, the decision about whether to invite in the first place is tough, but he's very much against disinvitations once invitations have been offered, and against student protests. But more to the point, after hearing Brandeis and all that, do you think it's appropriate for students to shout down speakers with whom they disagree?
I don't think it's appropriate. I just think that fundamentally the format with which, I just don't think that, within the, whatever 250 years Americans have had universities, there's been no fundamental change to the way in which, say, a campus lecture is conducted. And many students feel that, just having, 30 minutes to have a Q&A with a speaker whose ideas, they loathe and really want to attack, they don't think that that provides enough of a real forum. That's not a marketplace of ideas. That's a very limited window with which one can legitimately state one's viewpoint and actually have an active discussion. So I just think that American universities in particular need to have a legitimate discussion about how they could possibly reform the ways in which ideas which are hated by the majority of students can clash with them in a way that's actually productive, rather than causing all these unnecessary expenditures, violence, bloodshed. It's horrible hearing all these stories that just keep coming up in the news, and I think that there's a better way forward, and the system is broken, so we should fix it.
What about going to Facebook and really engaging these speakers? In the old days, a long time ago, the New Republic published Charles Murray right when the bell curve came out, and I was writing for it. And we staffers were really upset, and we all wrote responses. And there's no internet, and it was a big deal. But we took the time and we dug in and we read it and we responded. So why not just go to the blogs and really attack Charles Murray?
I mean, at least what I've seen in the aftermath of a lot of these events is students just gather in their online enclaves, and it's an echo chamber. Typically, online discourse, in my opinion, I think there is definitely a value to human contact. The reason why lecture series continue to thrive is that colleges and universities do value the fact that the actual human beings who created their works come and you can meet them face to face and debate them. So I think that that aspect is essential, but I think that the way in which it's conducted isn't. I think perhaps if students prior to the lecture coming, if there's a video perhaps that they could absorb the material that way to then preserve much more precious time so that the students could actually engage face to face, as opposed to having a dynamic where they have to squeeze in questions. And oftentimes, like Milo, for instance, will shout down and harass people as they're giving their questions. And I think that's just a level of decency and disrespect that shouldn't be welcome to the college campus, and they shouldn't have to be forced to pay millions of dollars to protect students, protect protesters. It's just a system that's ridiculous. So I think that there are just some changes fundamentally to the way in which a campus lecture is conducted that could potentially still allow for human-to-human connections between students and controversial speakers, but that just saves money and actually provokes deliberative discourse.
Those are great. Let me just say one thing that for me, this discussion is meaningful. I meant it when I said I came here. This is a big deal for me to try to persuade you about this sermon, as Professor Fish said, that these ideas are correct. And the fact that we're talking face to face and you listened, and were you persuaded by anything I said?
Yeah, I definitely am. I studied Fed 10 and J.S. Mill and Pericles last year in our great Quest for Justice course here. Shout out to Kenyon. Lisa Leibowitz, really great professor. So yeah, a lot of those ideas I had recalled, and they definitely resonate with me. And I for sure believe that, as Professor Stanley Fish said, more speech rather than less speech is essential. So I believe with all these principles of free speech, it's more that when they are enacted, when they're actually utilized by students, like they feel like they're not able to use those tools of free speech adequately to defend, to contest these ideas which they really loathe and really want to be able to deal with. So they shout down because they feel weakened, because they feel powerless, because finally the format, the way in which these ideas are brought to campus, the way in which they are presented, the small window of opportunity they have. Time and time again, I read in the New York Times in the aftermath of the horrible incident at Middlebury, several students said that the fundamental format of how the lecture series was presented, the sanctioning by the president, as well as the fact that they only had a week to prepare in terms of reading his material, understanding his arguments. It just set up a scenario in which the student body was unprepared to adequately meet his speech with more speech.
Well, you know what would be great? You're talking about ways of promoting thoughtful deliberation and exchange, which is the whole thing we're talking about. That's what the whole constitutional system is set up about. So why don't you follow up with this amazing center and, sorry for more homework, and maybe you can ignore it, but come up with some procedures that you think would empower students to respond, a kind of protocol that would allow them to speak and be heard, and promote the kind of deliberation you're talking about. That could be a huge contribution to public.
Yeah, I definitely think that would be a better solution than just all this wasteless expenditure of money of universities and potential for bloodshed. So, yeah.
Thank you for a great exchange. Really appreciate it. Professor Volokh.
So, Jeff, as you might gather, I agree pretty much entirely with what you say, but I couldn't.
Thank you. You're so bright and insightful.
Yes, yes. You're all such reasonable people.
Absolutely.
You and I. But I couldn't help thinking about my co-blogger Ilya Somin, who writes about political ignorance, voter ignorance. Not to condemn it, but just to state it as a reality. So if he were here and if he were inclined to disagree in some measure, here's what I think he might say, and I'd love to hear what you think. That if you set aside the question of whether Congress should be deliberating better or worse, maybe secretly or not, that's not so much an issue for free speech among the public, although it may be relevant to free speech or debate clause or open versus closed proceedings. And you focus on Brandeis's vision of deliberation by the public. One difficulty is the government is so large and deals with so many problems, especially at the federal level, which are also just reality, regardless of the size of government, are of such immense complexity and factual complexity, so you couldn't figure out, based on moral first principles, how to deal with these issues. That it's a pipe dream to imagine the public actually debating really carefully all sorts of questions like this, whether it has to do with how to deal with North Korea, or whether it has to do with how to deal with global warming, or whether it has to do with how to deal with crime or whatever else. The bottom line is that except for a few enthusiasts who are super excited and are willing to make it a hobby, the typical citizen, even if he were relatively civic-minded, which many people are not, just doesn't have the time on top of work duties, childcare duties, everything else, to go out there and actually educate himself in any material way on that. So that certainly on the qualifications of candidates, which often has to turn on a wide array of issues, at least ballot measures, you could say, well, you could study this one issue, but for deciding whom to vote for president, you have to hear all of these things. What realistically is the value of this kind of debate, at least as to fact-intensive questions, when the overwhelming majority of voters are not going to, for perfectly understandable, rational reasons, are not going to educate themselves well on subjects that a good education may take years?
It's a very important question. It's a very Brandeisian question as well. And Ilya Somin, who is a very thoughtful blogger, just noted the results of the recent Annenberg survey, which shows that only 1/3 of Americans can name all 3 branches of government, and 1/3 cannot name a single branch. So Eugene Volokh asks, and
I know.
You do, right? I would ask you when I forgot one. That's great. But the problem of leisure was not new to Brandeis. Brandeis believes that we have a duty to use our leisure time to educate ourselves. And he was so excited to learn that the Greek word for leisure is askolai, if I'm not mispronouncing it, or unemployment. He said, what a happy land that considers unemployment a form of leisure, whereas skolai is employment. And Brandeis says we need to encourage citizens to use their moments of leisure to learn about facts and about, bless you, and about the Constitution, and not to watch cat videos or amuse ourselves to death. And you say, was Brandeis too idealistic? Well, the entire mission of the Constitution Center is that Brandeis was not too idealistic. So Eugene, I think, did I start by plugging the interactive Constitution? I forgot how quickly I didn't. Oh my goodness. Ladies and gentlemen, the answer to Eugene's question, how can citizens be inspired to learn about the Constitution, is this thrilling new app produced by the National Constitution Center called the Interactive Constitution. And I want you to download it, not now because I'm talking, but after the answer to this question. And it's co-produced by the Federalist Society, the leading conservative lawyers organization in America, and the American Constitution Society, the leading liberal organization. And they've nominated scholars to write about every clause of the Constitution, describing what they agree about and what they disagree about. So you can go to the First Amendment and see Eugene Volokh and Jeff Stone, Eugene nominated by the Federalist Society, Jeff Stone by the American Constitution Society, with 1,000 words about what they believe the First Amendment means, and then separate statements about what they disagree. Multiply that by all 80 clauses of the Constitution, from the Foreign Emoluments Clause to the Export and Port Preference Clause, and you have a constitutional feast. I believe that it is your duty to download the Interactive and to learn about it, as is mine, because I don't know about most of these clauses either, and I'm supposed to teach this stuff. I have a lot to learn, but what I'm telling you is I am idealistic about the fact that citizens, when presented with rigorous material and told about its importance, can absorb it. 11 million people have downloaded the Interactive Constitution since it launched a year and a half ago. These podcasts that we're doing are getting 100,000 downloads a week. My point is that Brandeis never thought that everyone was going to develop their faculties and rise to the challenge of self-education. But you can, and you can, and you can, and I can, and by inspiring our fellow citizens to do it, we can make American democracy possible. So I think the answer has to be, it can't be that people are too busy or too uninformed. We have a duty to inspire them to learn, and all of us have a duty to learn together.
Hi, I'm Jessie. I'm from Berkeley, California. We've talked a lot about a free market of ideas here today, and as any student of economics like myself would know, to have a true free market, you have to have perfect competition. And the Supreme Court's decision to hold political speech as the most important, to the extent that corporations are allowed to equally engage in political speech, doesn't quite, in my mind, necessarily allow for perfect competition in the marketplace of free ideas, because these corporations have disproportionate access to resources and ability to disseminate their ideas compared to an individual like myself. So shouldn't the jurisprudence be, as any good regulatory body, shouldn't the jurisprudence around this idea attempt to regulate the ability for perfect competition to exist in this free marketplace of ideas?
Jeff, could we go ahead and take maybe a couple more questions together before you start answering that? Maybe all three of you?
Sure. My question is, I wanted to know, it's a simple question, but it's not as facetiously, where do rights come from? That is, what are the basis or foundation of rights? And if most Americans can't answer that question, are American freedoms in danger?
Hi. So my question has to do with kind of the nature of online discourse and debate. In this Trump administration, this period right now, it seems kind of like we're in a bit of a post-truth world, and I kind of am starting to feel jaded about knowledge and people's motivation to actually find the truth. And I was just wondering how you feel we can better engage online and what role empathy can play in free speech.
What three great questions. Wow, Citizens United, really important question. What would Brandeis think of Citizens United? I asked Justice Ginsburg that question. I got to interview her for this book on Brandeis, I thought. And she said Brandeis would not have been a fan of Citizens United, not at all. According to Justice Ginsburg, and I agree with her, Brandeis was a foe of the curse of corporate bigness. He supported the progressive era laws like the Tillman Law that regulated corporations and unions, if you believe that the right of speech is a natural right that comes from God or nature and not from government, then certainly large corporations, as opposed to small family-held ones, are hard to think of as having this natural right, and curbing corporate influence in the marketplace of ideas is legitimate. There is an argument on the other side, and I do believe that the well, let me finish by defending the Roberts argument on behalf of. Well, I'll answer that. Facebook or the New York Times might be considered a press corporation covered by the press clause. That's what Justice Stevens said in his Citizens United dissent, that certain corporations that are designed for express speech purposes can be treated differently than other corporations. So the New York Times is different than Exxon. And Facebook is a tough case because it claims that it's not making editorial decisions in order to get immunity from liability under the Communications Decency Act, but might then claim that it's a press. So hard cases, but you could distinguish between certain kinds of corporations and others. But I don't think that the Chief Justice Roberts and Justice Kennedy were favoring corporations for political reasons if you believe that all speech must be admitted into the marketplace of ideas, and that money is speech, and that people who assume corporate forms are as entitled to have their views heard as anyone else. You know, and sort of syllogistically, you can see where Citizens United got. I just agree with Brandeis and Justice Ginsburg and think he would have been in dissent in Citizens United. Where do rights come from? Brandeis and Jefferson said they come from God or nature's God, not government. The Bill of Rights did not create the First Amendment. Madison initially believed there was no need for a Bill of Rights or a First Amendment, and that a Bill of Rights would be unnecessary or dangerous. Unnecessary because the Constitution was itself a Bill of Rights, and because it gave Congress no power to infringe speech, we needn't fear that Congress would do so. And dangerous because our rights from God or nature are so capacious that people might wrongly assume that if a right isn't written down, it's not protected. But in the face of objections from the heroic anti-federalists led by George Mason of Virginia, Madison changed his mind. And the fact that he almost lost a House election in Virginia concentrated his mind, and he came to believe better safe than sorry, and he drafted the Bill of Rights. But he didn't believe that the First Amendment was creating the right of free speech. He cut and pasted from the Revolutionary Era State Declaration of Rights, passed between 1776 and 1780. Another plug for the interactive Constitution. Another amazing thing that you can do on this online tool, which is entirely free, unlike a Ginsu knife salesman. That's not all. You can click on the First Amendment and see its Revolutionary Era sources in the Colonial Bill of Rights. So you can see the Massachusetts Constitution of 1780, which declares speech to be a natural right, and the New Hampshire Constitution, which sets out, which answers your question and said all men in a state of nature are endowed by rights by God or nature and not government, and when they form civil society, they retain some and surrender others. So the Bill of Rights is declaring these natural or inherent or God-given rights, not creating them, and at least according to the framers of the US Constitution and Justice Louis Brandeis, that's where rights come from. What about empathy? And what about a post-fact society? I mean, that's a good note to end on because it's so important. So my kids are 11, and one of them recently said, you know, how can I trust this? Maybe it's fake news. And we had a very serious discussion, because if my kids and you can't have faith that they have an ability to distinguish real and fake news and that everything is relative, then there's no future for democracy. So I said very sternly, and you know, you can tell I'm very enthusiastic about these things, you have an obligation to investigate the facts rigorously enough to decide for yourself whether this is true or false. Facts are true or false, and you can read the best arguments on both sides, and you can take the time to seek out the competing arguments so that you can rationally evaluate them. But to do that requires, and your word is so perfect, it requires empathy. It requires a sympathetic imagination for the other side. It requires the humility to recognize that you might be wrong. The spirit of law is the spirit that's not too sure it's right, said learned hand. That just because someone disagrees with you politically doesn't mean they're a knave or a fool, and to try to put yourself in the other person's shoes and to realize that there might be a good argument on the other side. That's the beauty of this American constitutional tradition. There's something so moving about the fact that there are majority opinions and dissents, because it's really a testimony to the possibility of the rule of law. People argue and reason together, but eventually there's a rule that both sides are committed to accept. So please, whatever else it's a cynical time, and it's an anxious time, and people are polarized, and we're not going to convince ourselves politically. But the one thing that we must unite around and that we can't lose faith in is this document that unites us, which is the US Constitution and the First Amendment. Unless we continue to have faith, at least in the possibility of reasoning together, and have enough empathy to think that someone who we disagree with might possibly be right, then this beautiful experiment will fail. But I'm optimistic. Brandeis was optimistic. He always said, my faith in time is great. Time is the omnipotent, the great teacher. So this reasoned discussion has been really meaningful for me. Your questions have been great. The fact that we've taken the time to reason together and is meaningful. And I am optimistic, therefore, about the future of the First Amendment and American democracy. Thank you so much.